Hello and welcome to this podcast on the English and Welsh legal system with Dr. Ryan Murphy. Today we are going to explore how the English and Welsh legal system interacts or has potential to interact with other jurisdictions. And in particular, we're going to talk about the Commonwealth, British Overseas Territories and Crown Dependencies. And so you'll see from the cover of the book and from one of the early chapters that the territory of the United Kingdom is actually made up of a combination of different jurisdictions, legal jurisdictions, including that of England and Wales. And what I want to do in this short podcast is to explore some of the other jurisdictions that have a relationship with the territory of the United Kingdom. So let's begin and set out some of this context. So when we talk about English law, we are talking about law passed by the United Kingdom Parliament. And some of that law, some of the laws passed by the UK Act of Parliament, can have an impact on multiple jurisdictions, and specifically the jurisdictions that are mentioned in the textbook, so the jurisdictions of England and Wales, Scotland, and of Northern Ireland. But actually, this concept of the law passed by the United Kingdom Parliament, English law, can have an impact even beyond those territories, even beyond those legal jurisdictions. And actually, some of the personnel of the legal system of England and Wales are shared with other territories and other jurisdictions. And so some of the judiciary in particular will sit on cases not only governing English law, but also, where relevant, the law of other jurisdictions. And some of the institutions of the English legal system are shared with those other territories and jurisdictions. So in particular, if you think of Parliament, or the law of Parliament, or some of the law of Parliament is shared with some of the other jurisdictions. And what we're going to do is we're going to rattle through three different sorts of territories, of areas, where English law, UK law, can still have some form of influence. So we're going to start with the British Overseas Territories, the BOTs. And if we think of the political environment of these areas, they are self-governing. So they have a form of independence. They're largely made up of former crown colonies. So areas that used to come under, and still do, in some instances, the authority of the monarch. The role for the UK in these British Overseas Territory is largely reserved to matters of defence and matters of foreign affairs. And so they're internally self-governing, but some of the more outward functions of statehood, of sovereignty, are actually exercised by or in conjunction with the United Kingdom. If we think of how lawmaking operates in these British Overseas Territories, there is a set of local legislation, and the local legislation will govern the majority of the activities within these territories, within these British Overseas Territories. Laid over that, acts of the United Kingdom Parliament can form part of the legislation for these British Overseas Territories. And often, but not always, there will be an ordering council that establishes a constitution for these British Overseas Territories. And so there was an act of recognition of the independence of the sovereignty of these British Overseas Territories. And that's often been recognised through an ordering council which will establish a constitution. And other UK legislation might be incorporated into local legislation. So it becomes part of the domestic legal order of the British Overseas Territory through incorporation. So these are acts or legislative instruments of the UK Parliament, UK legislation, which is then incorporated into local legislation. If we move then from that idea of the political environment, the framework for lawmaking, to the legal system. So these British Overseas Territories have a set of independent courts. These independent courts are normally founded on principles of common law. So they share that same legal heritage as the legal system of England and Wales, in the fact that it's a common law-based system. And they have a series of independent courts, and often the most senior court will be a shared court. So they can share courts between themselves, or there is a shared court with the United Kingdom legal order. So that shared institution that we mentioned right at the start, the most obvious of those shared institutions is the Privy Council. And so you may come across cases that were decided by the Judicial Committee of the Privy Council. And the Privy Council was the Queen's advisors, and the Judicial Committee will normally, or does contain, the senior judges from the United Kingdom, from the legal system of England and Wales, so the members of the UK Supreme Court, and crucially, judges from jurisdictions other than the United Kingdom, where that particular territory case is in question. So you have these independent courts based on the common law system, and then this sharing of the senior judges of the legal system of England and Wales, most notably the UK Supreme Court. Now, this can lead to some problems. This complex constitutional arrangement, which works very well in some instances, can lead to particular difficulties. And Mizik is a good example of how this complicated constitutional framework can lead to particular problems for these British Overseas Territories, and indeed for the legitimacy of aspects of the legal system of England and Wales. So, in Mizik, you have corruption on a grand scale undertaken by members of the governing party on the Turks and Caicos Islands, which is one of the British Overseas Territories. So you have a self-governing British Overseas Territory, the Turks and Caicos Islands, and it's found that over a very large number, very many years, there's been significant corruption. And so Westminster, the Westminster Parliament, the UK Parliament, suspends the island's constitution. So you have these interactions. Can you see the interactions between the different legal systems? You have a self-governing former Crown colony, a British Overseas Territory, which governance has pretty much broken down. The constitution, which had been granted through an order in council, was suspended by the UK Parliament. So you have the UK Parliament interfering or taking part, or protecting, or however you want to frame it will depend on your view of this sort of constitutional arrangement. But you have a suspension of the island's constitution. Eventually, that constitution is reinstated, but there are changes made to the constitution. One of the changes is that there is now the possibility in certain cases, including this sort of corruption and money laundering by part of the political class, will take place without a jury. The thinking behind this was that jury trials are really quite important, that they are a cornerstone of most liberal democracies, but that on a very, very small territory, like the Turks and Caicos Island, the islands. The issue is that many people will be related to, will know, will have an affiliation with that former governing party. And the potential for an independent jury is much reduced. And so you have failure in governance of the British Overseas Territory, you have the removal of the Constitution, or the suspension of the Constitution by the Westminster Parliament, by the UK Parliament. It's then reintroduced, but removing one of the fundamental principles of many liberal democracies. What happens is the Mizik is charged with corruption and money laundering. He's put on trial without a jury because of the difficulties in securing an independent jury, and he challenges the lawfulness of that decision. And it goes all the way up to the Privy Council. So now not only has the UK Parliament been involved, or the Westminster Parliament been involved in suspending the Constitution and changing the Constitution of the British Overseas Territory, but now the judiciary are also involved in this debacle, in this saga. The challenge to the Privy Council was ultimately unsuccessful. The Privy Council, which was made up of members of the Supreme Court, who sit in both capacities, found that it was lawful to hold a trial without jury under these rather extreme circumstances. But the point of this exercise is not necessarily to look at the very, very granular detail of the Mizik judgment, but rather to demonstrate to you the interconnectedness of jurisdictions, how one jurisdiction can influence other jurisdictions. And when we talk about the legal system of England and Wales, we need to put it into that broader framework of shared institutions and shared understandings, and in most cases, shared values. So there are 14 of these British overseas territories. There are some of them are mentioned on the screen here, but there are, of course, more. If we then look to a different sort of territory which has a relationship with the United Kingdom, we have the Crown Dependencies. So these are areas which, in international law, for which the UK is responsible. But the UK largely leaves these territories to govern themselves. So these are Guernsey, Jersey, and the Isle of Man. So you have 3 Crown dependencies. They are self-governing, that unlike one of the distinguishing features between these Crown dependencies and the British Overseas Territories that we just spoke about was that most of these do not have constitutions that derive from an instrument originating in the UK. So it doesn't come from an ordering council. That whilst they have elected legislatures which pass law, they share one of the great institutions of the legal system of England and Wales, and that's the monarch. So there is still required to be royal assent on legislation that stems from these Crown dependencies. The way in which that operates in practice is quite different to how it operates in the Westminster Parliament in the UK, but the technicality, the technical need to have part of that shared lawmaking process, royal assent, is still an important feature. So these UK legislation can also extend to these dependencies. So either by the Act of Parliament itself saying that it extends to these territories, or by ordering council making that extension of acts of the UK Parliament. It has become a constitutional convention, however, that consent of the islands, so the consent of Guernsey, Jersey, and the Isle of Man, would be sought and granted before the extension of a UK Act of Parliament to cover that Crown dependence. It has its own legal system. So the Crown dependency have their own system of courts, but again, there is a reliance on the Judicial Committee of the Privy Council. And then finally, looking at a different set of jurisdictions which have a constitutional relationship, or have had a constitutional relationship with the United Kingdom, we look at the Commonwealth. Now, the nature of the Commonwealth has changed quite significantly over the years, and now largely this is a political association. It contains more than 50 states. Many of them are former British Empire territories. So if you think of Australia, if you think of Canada, if you think of New Zealand, 16 of which still have the Queen, so the Queen of England, as their constitutional head of state as well. And so you can see where some of that shared framework comes from traditionally. So at the moment, Queen Elizabeth II, at the time of recording, leads the organisation. And it's been decided by the heads of government of the Commonwealth of Nations that Prince Charles will succeed her when she is unable to continue to lead the organisation through death or disablement. Now, this is not a hereditary position. This is the leading of the political association. There is no shared legal system between the Commonwealth of Nations and the United Kingdom. There has been a break. Each is an independent sovereign nation of their own. But for some jurisdictions, the Privy Council acts as the final court. So the Privy Council acts as the final court for a number of the jurisdictions within the Commonwealth, whilst jurisdiction over other members of the Commonwealth has faded. So, for example, Australia, Canada, India, Malaysia now have their own Supreme Courts, and either will not as a matter of practice or will not as a matter of law have resort to the Privy Council. So there you have it, just a very brief examination of the way in which the law which governs England and Wales also can potentially have an impact on other jurisdictions, other territories, whether that's as British overseas territories, as Crown dependencies, or as part of the Commonwealth of Nations. Thank you very much.